Hey out there, legal warriors. Avoid these 5 crucial mistakes if you're pulled over for investigation of DUI, driving under the influence. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. I'm just going to jump right into it. DUI, driving under the influence. Let's hope none of us are ever in the situation where we're pulled over after we've been drinking, because again, we should not drink and drive. While this video isn't legal advice, I'm going to cover 5 crucial mistakes to avoid should you or someone you know be in the unfortunate situation of being pulled over for DUI. Let's just jump right into it. I think the first and most crucial mistake people make, they're pulled over for DUI, they're on the side of the road, they've stopped, and the officer comes walking up to the car, oftentimes to the passenger side, if it's on an interstate where it's more safe. But usually the officer's going to ask, have you been drinking? And the biggest mistake most people make is one, yes, admitting to drinking, right? We don't have to talk about anything when we talk to a police officer. We don't even have to answer that question. Now, we're not supposed to lie to an officer, but generally speaking, saying I've had a couple drinks really isn't going to help us. So we can either not answer the question, we could assert that we haven't been drinking because they're going to need to prove that later. But if we admit to drinking, that gives them one more step towards what? Gives them one more step towards probable cause to arrest. Gives them a reason to get us out of the car. Gives them a reason to ask us to do field sobriety tests. Gives us a reason to extend the detention besides the reason for the stop. If they just pull you over for speeding, they can't continue the stop beyond a normal traffic stop unless they have a reason to believe something else is going on, like DUI. And speeding less than 15 under the limit is not a cue for DUI. So that's why they ask, right? They ask, have you been drinking? Because once you say yes, now they pretty much have an automatic justification to continue the detention. So if we don't answer that question or we say no, now we have more things we can challenge on the defense side about whether or not the extension of the detention was reasonable or they should have let you go sooner. Number 2, the second mistake people do, and this is a much bigger mistake, is agreeing to do roadside field sobriety tests. So what do you mean roadside field sobriety test? Roadside field sobriety test is where the officer says, hey, would you mind if you do some tests so I can see if you're okay to drive? And you're lucky if they say that. They might say, I'm going to have you do some tests to see if you're okay to drive. In Washington state, you don't have any consequences for refusing field sobriety tests. There may be some states out there where that's the case, and I'm only practicing in Washington state. Here, it's generally never a good idea to agree to do field sobriety tests. Why? Because field sobriety tests are subjective. There's 3 standardized field sobriety tests that happen all throughout the United States. They are put out by very old studies from the National Highway and Traffic Safety Administration. And those 3 tests are the horizontal gaze nystagmus, where they check your eyes to see if they equally track and if they sort of jump around. And the theory is if they jump when the stimulus is going back and forth, that means you've been drinking. It's not even really validated for being drunk, it's only drinking. Second is the walk and turn test. Now that test is a disaster. You have to take 9 heel-to-toe steps down a line, turn in a prescribed manner, and then take 9 heel-to-toe steps back. And there's not even usually a line that you're walking on. There's an imaginary line. There's 8 different clues they're looking for in that particular test. If you just score 2 clues, that's a fail, and it's really impossible to pass because the officer rattles off the instructions really quick. You're nervous, you're on the side of the road. Who knows if they even give you the instructions right? And it's subjective. They're going to see what they want to see and try to justify their arrest. And third is the one-leg stand. So you stand with one leg off the ground, approximately 6 inches, count out loud, 1001, 1002, 1003, and so forth until an officer tells you to stop. They're looking for 4 clues there, 2 of which is a fail. They're looking for swaying, which is undefined, right? Whatever they say is swaying, hopping, using your arms for balance, also pretty much undefined for that test. very difficult, if not impossible, to pass, especially in a high-pressure situation where it's late at night, you've never practiced it before. So why are they asking for the field sobriety test? To take that next step, to justify the arrest, to say I have probable cause to believe that this driver is driving under the influence. So what do they typically have? Some type of driving, the admission of drinking, that was mistake one, and the field sobriety test, which you can't pass because they're subjective and they're just too hard to do to begin with. So then there's an arrest. So what's the third mistake that people make? Okay, we've got admitting to drinking, and we have doing a field sobriety test. Well, the next step after the field sobriety test usually is, hey, would you mind taking this portable breath test so I can see if you're okay? Well, in Washington State, the portable breath test is also voluntary. That's a handheld device. I could have brought one here for the video. I have one at home. It's a handheld device that you blow into, and it's really for the officer to make a determination if they're right or not. The officer's going to tell you, hey, it doesn't really count. It's not admissible. Well, that's technically true. It's not admissible in court as substantive evidence. It is actually used. Okay, the prosecutor sees it and goes, oh, the portable breath test was a high number, therefore I'm going to be harder on this person. Or it could be used, the portable breath test was a lower number, depends where you're at. But while it's technically not admissible, it's still not going to help you, right? The portable breath test typically does not help the driver. Now, if you've had nothing to drink whatsoever, well, then the portable breath test might. But I'm assuming in this particular case that we're worried about, hey, we've had something to drink. We're worried about what stuff is going to show. So usually the mistake people make is agreeing to the portable breath test. So what have we learned so far? We've learned we really shouldn't talk to the police much when they pull us over. We shouldn't agree to any voluntary field tests. We shouldn't agree to any voluntary portable breath test. So at this point now, we're under arrest, right? So they take us to a police station typically to ask us for a breath test. And the fourth mistake that we see most people make is agreeing to answer the DUI interview questions. That absolutely cannot help somebody. The DUI interview questions in Washington State are standardized questions, about 32 questions, where they're going to try to cut off the defenses of the driver. Without looking at a clock or your watch, what time do you think it is? Well, who knows? You probably don't know the time, but if you don't know the time, you're drunk, right? Are you under the care of a doctor or a dentist? Well, no. Well, when you later say, rightfully so, you have knee problems or back problems or stuff like that, well, you're not under the care of a doctor or dentist, so you must be making that up now after the fact. They'll say, do you believe your ability to drive was affected by the alcohol or drugs you used tonight or today? And that answer, if you say yes, you've just admitted to the crime altogether, right? Hey, yeah, it might have had an effect. I'll say yes to that. Well, automatically guilty at that point. DUI, you can be proven guilty in two ways: having a 0.08 or higher breath test for alcohol if you're an adult, or there's also marijuana, or if there's no breath test or you're under an 0.08, your ability to drive affected by alcohol or drugs. That's why they ask that question. If you say yes to that question, now they've just slam dunked their case against you based upon your own admission. They'll also ask you how many hours of sleep you had last night, because some defenses to DUI, tiredness can mimic drunkenness, right? And so if you had 9 hours sleep, you must not have been tired, right? They'll ask you all of these questions and they cannot help you, right? They cannot help you. So that's a huge mistake people make, is answering the DUI interview questions. We have a right to remain silent, and we should use that right to remain silent. And I think the final one, and it'd be surprising, I'm not going to talk about whether or not you should take the breath test, whether or not that's a mistake, because that's pretty individualized. But the fifth one, and it's very clear as a mistake, is not asking to speak to an attorney at the station. I would say 90% of the people that come into my office for a DUI charge have not asked to speak to the public defender or their own private attorney if they happen to know one or have one during the time of arrest. And that's a huge, huge mistake, because if you can talk privately to an attorney, a public defender, private attorney, during this arrest process, they're going to tell you, don't answer the questions. They're going to ask you some questions about how much you had to drink to help you decide whether or not to take the breath test. They're going to tell the officer not to ask you some questions. And if the officer doesn't give you privacy when you're speaking to this attorney, and you ask for privacy, that can suppress the entire breath test. So again, there is no downside in asking for a chance to speak to a public defender or a private attorney. It's your right. And most people don't do it because I think they feel so bad they're in a situation they want to cooperate. I'm cooperating, I'm cooperating. You're still cooperating if you ask to speak to an attorney. That's your rights, right? And you need some advice during that period of time. So if you do ask to speak to an attorney, make sure you ask for privacy and note in your mind whether or not the officer can hear you, right? There's different breath test rooms all throughout Washington State. Some could have an area where the door has to be open and the officer can hear you. Well, if the officer can hear you, you can't really speak frankly to your attorney, can you? And that sort of violates that attorney-client privilege. Or if case law is pretty bad, it makes you ask for privacy. If you ask for privacy and the officer doesn't give it to you, make sure you write that down right away to tell your attorney once you talk to an attorney, so that can be an issue that gets brought up, because many of these breath test rooms have a video in them. They may not have audio, but they have video, and sometimes we can use that to help. So you need to ask for that attorney so that you have a chance to get some advice, and also some things can go wrong for the state's case if the state screws that up. So that's 5 big mistakes to avoid. Now, hopefully we're never in this situation. Not condoning driving drunk, but I am suggesting that we should do what we can to protect ourselves and make better decisions. If we've made a bad decision driving, make better decisions so we can have less of a consequence long-term against us if we're in this difficult situation. Okay? So if you found this useful, please like and please subscribe. More people get the help they need. And more importantly, if you've got a DUI type situation, any other type of crime in Washington State, feel free to reach out to my firm. We'll listen to what happened. We'll identify a way forward. We'll be there for you. Thank you.